I don't think it would hurt if you gave us a couple of minutes, Your Honor.
Okay.
And Your Honor, my client is going to be appearing by phone.
Okay, who said that?
Ms.
I
Acosta.
did.
Irene.
Okay, thank you.
Put the attorneys in a breakout room for a few minutes.
Thank you, Your Honor.
Judge, this is Maureen. Mr. Cardenas is here in the waiting room, he said.
I don't have anyone else in the waiting room that's not in the courtroom.
It's pronounced Cardenas instead of Cardenas. I've been mispronouncing it the whole time. I'm so sorry.
Cardenas. I will text him and make sure he has the correct ID and password.
Okay. Does anybody else need to confer in a different room?
No, Judge. And just for the court's knowledge, I'm requesting a pre-262 mediation to hammer out a few things with my client prior to going to a fully contested hearing.
Okay.
And I believe, Maureen, I didn't learn how to say your last name. Is it Giannis or Lanus?
The first one, you did it. Giannis.
Giannis.
Yes.
Okay. Well, my name is Versal and people mispronounce it all the time, so I kind of get used to it. I believe Miss Giannis is going to join in Miss Acosta's request.
Judge, this is kind of a different complex case, and we need a plan moving forward for both parents. You know, so that we're all on the same sheet of music.
I understand. Well, how much time do you need? Not for the mediation itself, but to get it set up and to get it mediated.
Obviously, Your Honor, I have no idea. I'm hoping people who do this know.
I would say about at least 3 weeks, because this week's going to be a wash.
Oh yeah, sweeps out.
No one's in.
And obviously, the department would ask that everybody waive the additional time, waive the requirement for an agreement for the additional time over 2 weeks past the ex parte expiration to allow the ex parte to be continued.
Judge, how much time are they going to need for the hearing? That I need to know.
If it's agreed, obviously not long. If it's not agreed, Miss Acosta mentioned 4 to 5 hours.
I don't know how contested it's going to be, and I know that there's quite a few witnesses that the department might potentially call. So I'm not sure, but I don't think we're going to need that many, to be honest.
Well, Judge, we have July 18th. That's a Uvalde date, but there's nothing set that day. So we have that option. Beyond that, you are out of town and Kathy is not going to hear a big contested hearing.
Let's do July 18th.
Okay, and Your Honor, somebody else will be covering for me, but we will take care of it. That's my regular docket day in Montag.
And I would make the suggestion, Judge, since we've had issues with getting mediation set, that this be ordered to be set within 24 hours, because otherwise we're not going to have a date for this hearing to be done if they can't mediate in that time period.
Okay, my only issue is obviously Lorraine sets that up and she's going to have to find a mediator who's going to do it, and then everybody's going to have to agree on a date. Once again, I don't think there's a problem from the department side, but I don't know about the other attorneys if it's going to be difficult for them to come up with a date within 24 hours.
Maybe we can go into a breakout room briefly and come up with an agreed date amongst the attorneys that are going to be there, and then we can base our mediator off of who's available on that day.
Sounds like a plan. I'd like to appear just so I can tell Lorraine what's going on.
Yes, in the 198 Judicial District Court of Bandera County, Texas. Any objections?
No objection.
No objection.
All right. I do apologize. Miss Rush, go ahead and do the announcements.
Versal Rush and John Carter for the Department of Family and Protective Services. Ready.
Irene Acosta, attorney appointed to represent the respondent mother.
Maureen Llanos, for the father, Alfonso Cardenas. He is present via Zoom, Judge. Mr. Cardenas, will you unmute and announce?
Yes, hi, Alfonso Cardenas in the meeting.
Jennifer Harris, attorney ad litem for the child. I'm ready.
Bobby Bryant, Hill Country Guardian. And Goldie Rapson, Hill Country Casa Guardian ad litem supervisor.
Do the parties still agree to a pre-262 mediation?
Yes, sir.
All right. Did you all select a date and a mediator?
Yes, sir. Miss Acosta was very helpful, and she got Leah, whose last name I've just blanked out on,
Peterson.
Leah Peterson, for 2 p.m. July 15th, and the attorneys are available.
Did you say July 15th?
Yes, sir. It's the first date the non-me's are available.
There's no objection from any party to the mediation, correct?
No, Your Honor.
Yes, sir. Correct.
There's
No
no
objection.
objection from any party regarding extending the emergency orders and going past the deadline.
No objection, Judge.
No
None.
objection.
Okay. Then I'm going to go ahead and grant the party's request to hold a pre-262 mediation. I'm going to order the parties to mediate this case with Leah Peterson as mediator, July the 15th, 2024 at 2 p.m. Parents are ordered to attend this mediation, and all parties or their attorneys are ordered to sign the emergency order extending jurisdiction before the court receives the order.
Yes, sir.
And we will reset our adversary hearing to July 18th at 9:30.
Yes, sir.
So all parties are ordered to appear at that date and time for the adversary hearing. Anything else?
Not from the department. Thank you, sir.
No, Your Honor.
Okay. Thank you all for your time and your service. If nothing further, all parties are excused.
Thank you, sir.
Do we need to do any conferring before we get started on this?
No, Judge.
And how do the parties wish to proceed, just so I know?
Yeah, Judge, we did attend mediation on the 15th, so I believe that's Monday, and we did reach an agreement.
Okay.
And Your Honor, just for the court's knowledge, the mother wasn't a party to that agreement.
Okay. Is she here today?
I don't see her.
Okay. So then what's the plan as far as the mother's concerned?
So, Judge, the agreement that was reached actually is for the department to place the child with her father, Mr. Cardenas, and actually dismiss the suit.
But mom's not a part of that?
She's not, Judge.
Is that Mr. Cardenas right there?
Yes, Judge, the LG.
Okay. Thank you. That's in the 198 Judicial District Court of Bandera County, Texas. The court is streaming from Kendall County Courthouse via YouTube and Zoom. Are there any objections?
No objection.
No objection.
No objection.
All right. Mr. McKeska, would you please begin the announcements then?
Yes, Judge. Drake McCaskill, attorney for the department.
Ashley Crouch, Following Permanency Supervisor.
Irene Acosta, attorney for the mother. She is not present, but I believe she was aware of the proceedings today, and she did attend mediation, so she's aware of how everything is moving forward, although she's not in agreement.
Maureen, oh, go ahead,
Go
Judge.
ahead, Ms. Yanis.
Maureen Yanis, attorney ad litem for the father, Alfonso Cardenas. He's present. Mr. Cardenas, would you mind unmuting your phone and announcing? Well, Judge, I think we can all confirm who that is.
Pressing the button to see if there he goes. Press it one more time, sir. There you go. Can you state your name?
Alfonso Cardina Jr.
All right, thank you. You can hang on just a second while I swear, everybody. Anybody else that hasn't announced yet?
Jennifer Harris, attorney ad litem for Savannah. I'm ready.
Goldie Rapson, Hill Country Casa, guardian ad litem for the child.
John Carter, Child Protective Service investigator.
Dustin Williams, Child Protection Investigations.
And if you could, please hold your device still or set it down. All right. So there's an agreement with the father to place the child at home and dismiss the suit, but mom's not party to that agreement. She doesn't agree with it. She's not here. All right. So you're gonna contest it, Ms. Acosta?
Your Honor, I think the only thing I can do is present the mother's position.
Okay. All right. Then how do you want to proceed right now, Mr. McCaskill?
Judge, I can read the terms, or at least the controlling terms of the agreement into the record, and then present argument on why I believe this is the best course of action in the best interest of the child.
I think that'd be fine to get us going, and if anybody else wants to present some evidence, they can do so. But that's a good start.
So, Judge, we like I stated, we did attend mediation on Monday afternoon and did reach an agreement with the father in which we would place the child with him. That Mr. Cardenas actually traveled and is in Texas now from California to Texas in order to receive the child from the department / belong at the child's current placement as coordinated between himself and the department. And as part of this, we agreed to non-suit the case. Just the legal basis for this request is Chapter 262.201G, in which a suit filed under 262.101 or 105 at the conclusion of the adversary hearing, the court shall order the return of the child to a parent. And I'm going to skip ahead from whom the child is removed unless the court finds sufficient to satisfy person of ordinary prudence and caution that there's continuing danger, there's urgent need for protection, and reasonable efforts were made to return him. Judge, prior to the mediation, Mr. Tucci, who's the assigned caseworker for Belong, did travel out to Mr. Cardenas's home in California, met with him and his family and support network, was able to walk through the home, and it was Mr. Tucci's recommendation that Savannah be placed with him and that he would be able to adequately meet her needs. And so that's the basis for the request today, because Mr. Cardenas is deemed an appropriate parent. We're asking the court to place with him and dismiss the suit today.
Okay. Ms. Acosta, response?
Your Honor, my client's position is that Savannah has never had a relationship with Mr. Cardina, and so taking a child who already has all of these needs, special needs, and placing her in a situation with a person who she has no relationship with is going to further possibly upset her, or I'm not sure. Mother is under the understanding that Savannah is currently in a group setting, getting support from professionals who are able to adequately address all of her current needs, and she feels that that is the best place for her at the current time. She didn't believe that, sending her to California with someone who hasn't been around, hasn't helped raise her, hasn't provided any support or parenting over this child's life, to just come in for the last 3 years of her life and take over. Mom's been, I guess, doing her best over the past, I would say, 15 years. And she really does believe that Savannah would do better in the group setting and in the conservatorship of the department.
Okay. Ms. Yanis? Before you go, Ms. Yanis, do we have service on the mother? I don't have it in my system, and I just want to make sure that.
Let me check now, Judge. The mother signed a waiver of service on June 19th of 2024.
Okay, thank you. Go ahead, Ms. Giannis.
Judge, no child belongs in foster care when there is a capable, appropriate parent who is willing to care for the child, is available to take the child. I get what mom is saying, that he wasn't there to he does have a relationship with her. He did live with the child when she was young. He did visit with the child maybe a couple of times when she was living in Bandera. I don't believe that mom's argument holds any water. He may not have been available 24/7 like mom was, but he was not involved in abuse or neglect of this child. And I would ask the court to approve and adopt that Rule 11 agreement and release the child to her father.
Thank you, Ms. Giannis. Ms. Harris?
I share the same position, Your Honor. We have a parent that there's no reason that shouldn't have his child, is willing to take his child, is here to take care of her, and there's no reason for the department to be involved when there's a father that can care for her. I think that's what our legislature has set up.
CASA is in agreement that it's in the child's best interest to go be with her father and the paternal side of the family. Based on the information we received from Belongs and visits with him and CASA's own visit with the father, they've got all the services. They're thinking about it. They're setting up education and doctors. So CASA feels this is in the best interest of the child.
And anything else from you, Mr. McKeska?
Judge, I would just say with all due respect to Ms. Muno's position, based on the allegations that contained in the affidavit, at best case scenario in this case is that the mother drove the child in the middle of the night to a Starbucks and dropped her off and left her. Worst case scenario, based on her own admissions contained in the affidavit, are that she was trying to have someone that she met on the internet adopt the child, and she thought that she was executing paperwork to that end. And so, like everybody else to say, because we have a parent who's willing to take this child, provide for her care, and is already taking steps necessary to ensure that her needs are met, there's no reason for the department's involvement at this point.
Thank you. Would it have been Mr. Carter or Mr. Williams that would have been testifying had this moved forward?
It would have been primarily Mr. Carter, Judge. He was the primary investigator on this case out of Bexar County.
Okay. Mr. Carter, do you believe that this agreement is in the best interest of the child?
Yes, Your Honor, I do. As the initial investigator on the case, again, as the attorney stated, Savannah was essentially abandoned by her mom. I can't speak to the dynamics of that, but it just seems odd to me that now she's willing to show some concern for the child when she had none. The child basically was a situation where the child could have died. I've talked to the father, and the father is willing and able to take care of Savannah. As far as Savannah not adjusting to that, I believe that I've spent some time with Savannah, and it doesn't take long for Savannah to acclimate to someone. I believe that it is in the best interest of Savannah to be with her father.
Thank you, Mr. Carter. Well, I did review the affidavit in this case initially, obviously, to bring it into our purview here, and I'm aware of the facts and the circumstances, and I can understand how mom might feel the way she does, and I appreciate your advocacy, Mr. Costa, but the weight of the evidence here and the professionals' opinions is that she needs to go with her father. But more so, as Mr. McKeska pointed out on 262-201G, with all the evidence that's in front of me, it doesn't give me any choice. She's got to go home to her dad in California. It says the court shall order the return of the child to the parent. It doesn't give me an option. So I'm going to approve the agreement of the parties, find that it's in the best interest of the child, and order that the departments return the child, Savannah, to her father, Mr. Alfonso Cardenas, to his custody today for him to take back with him to California. And the parties have agreed to dismiss this suit, so there will be no further hearings. I'll sign the dismissal when I get it. All right. Anything further from anyone else?
Your Honor, I just want to thank Mr. Cardenas and his family for getting on a plane and getting right out here. That would be difficult for all of us in the best of circumstances. So thank you for doing that, and I wish you luck.
All right. Thank you. Good luck to you, Mr. Cardenas, and thank you all for your time and your service. If nothing further, all parties are excused and there'll be no further hearings.
Thank you, Judge.
My understanding was that there might have been an agreement on this case. Is there not?
I think we can reach one, Your Honor. It was just really quick service and no one had the time to contact anybody else.
Well, no, I thought y'all actually had an agreement on this one. Okay. I'm going to put all of you in room 1. Are you all through conferring, or do you need to be split up anymore?
I think we're good, Your Honor.
Do you have an agreement, or do you need a hearing?
We have an agreement.
Okay. Ms. May, are you ready?
Yes, sir.
Casting via Zoom and YouTube from Kendall County. Are there any objections?
No, Your
No
Honor.
objection.
No objection.
With that, Ms. Rush, would you please, excuse me, Ms. Dominguez, would you please begin the announcements?
Yes, sir. Kern Dominguez for the department, Your Honor.
Regina Cecil, the investigator assigned to the case with the department.
Quincy Brandon, attorney for the mother. We're present and ready.
Richard Tolliver for the father. He's present. We're ready, Judge.
Irene Acosta for the child. I'm ready.
Amy Harding, Hill Country CASA supervisor, guardian ad litem for the child.
Can I get both the parents to announce, please?
Okay, both parents are here.
I'll need you to both state your names, please.
Christopher Spence.
Marcelina Gonzalez.
Thank you. All right, Ms. Dominguez, I show that both parents, in addition to appearing here today, were served June 26th by waiver. So
Yes, Your
with
Honor.
that, if you would please state the agreement on the record.
Yes, sir. The department shall be temporary managing conservator. The parents will be possessory conservators. They have agreed to do the standard initial things, Your Honor. Drug testing, OSAR assessment, drug and alcohol assessment, the psychological or psychiatric evaluation, and to follow all of those recommendations from the assessments. Parenting classes also, Your Honor. The child is placed with the paternal grandmother, and we've agreed that that is a placement for now. We are going to be completing the home study, and it's going to be requested that it be expedited. And we're also, in addition to this, asking for a hair follicle for the child. And I think that's it. Now, visitation, Your Honor. The couple have been coming together, so the department doesn't object to it being a 2-hour visit with both present, or a 1 hour for each, to be supervised by Belong. I believe that's everything. Oh, and we're not asking for child support or medical support, Your Honor, until further order of the court.
Ms. Cecil, do you hear the agreement that was stated on the record?
Yes, Your Honor.
Do you believe it's in the best interest of the child?
Yes, Your Honor, I do.
And to the best of your knowledge, is everything that was in your affidavit filed with this case true and correct?
Yes, Your Honor, it is.
And you believe that there was a danger to the child caused by an act or failure act of the parents, and that these services are necessary to protect the child and address the concerns that brought the child into care?
Yes, Your Honor, I do believe services are necessary.
And you believe that the department made all reasonable efforts to prevent a removal and to return the child home?
Yes, Your Honor.
Did the parties stipulate to the reasonable efforts stated in the affidavit?
Is that a question for me, Your Honor?
No, that's for the attorneys.
Yes, Your Honor.
No, yes, Judge.
Yes, Your Honor.
Yes, Your Honor.
Yes, Your Honor.
Thank you, Ms. Cecil. Mr. Brandon, is that your understanding of the agreement?
That is my understanding of the agreement.
Mr. Saldivar?
Yes, Judge, we're not admitting or conceding the allegations, but we are in agreement to that.
Acosta?
Yes, Your Honor, but I was also going to request daycare assistance for the placement. It's my understanding that she's going to need it eventually. And I'm also requesting that once school begins, that before and after school care be provided by Belong.
Okay. Casa?
This is our understanding of the agreement, Your Honor, and we believe that at this moment it's in Jayla's best interest for the parents to participate in services and for her to remain in the care of her grandmother at this time.
Good. Mr. Spence and Ms. Gonzalez, did you both hear the agreement?
Yes, sir.
Did you both have an opportunity? Ma'am, I need you to answer out loud. Did you both have the opportunity to discuss this agreement with your attorneys?
Yes, sir.
Yes.
And do you understand what's expected of you?
Yes, sir.
And were you forced into any agreements or made any promises or inducements to get you to agree to this?
No, sir.
Are you asking the court to adopt your voluntary agreement and make it an order of the court?
Yes, sir. We can do it.
Okay. Ma'am?
Yes.
Thank you. All right. Anything else that you want to add, Ms. Acosta, besides the daycare concerns?
Jayla is where she wants to be right now, so I'm glad that she's with her grandmother. I don't want this placement to break down because of, assistance issues. So I would request that the home study be expedited as well. I know it's been agreed to. And I would also ask Belong to sit down with the grandmother and find out who she has, who can also help her with Jayla as potential respite, so that those people are available to her if she needs someone to drive her to school or pick her up from school, or if she needs any other assistance with her, because at this point, at the beginning of August, it's just her. So I want her to have as much help as possible if she needs it.
Okay, thank you. Anything else from CASA?
No, Your Honor.
All right, then. Court finds that there's sufficient evidence to satisfy a person of ordinary prudence and caution that there was a danger to the physical health or safety of the child caused by an act or failure to act of the person entitled to possession, and for the child to remain in the home is contrary to the welfare of the child. The urgent need for protection required the immediate removal of the child, and reasonable efforts consistent with the circumstances and providing for the safety of the child were made to eliminate or prevent the child's removal. Reasonable efforts have been made to enable the child to return home, but there is a substantial risk of continuing danger if the child is returned home. Court will grant the parties' agreement and order that the Department of Family Protective Services be named as the temporary managing conservator of the child. The parents, Marcelina Gonzalez and Christopher Spence, shall be named as temporary possessory conservators of the child. Court will order the parties to hold a family group conference and to develop family plans of service that are narrowly tailored to address the concerns that brought the child in care, which shall include the standard services as stated by Ms. Dominguez on the record, as well as any other services parties feel are appropriate for this case. Court will order that the child remain placed with the paternal grandmother, order an expedited home study. Court finds at this time that placement is safe and appropriate, meeting her needs and in her best interest to continue. I'm going to order a hair follicle as requested on Jayla. I'm going to order that parents have 1 hour per week visitation supervised by Belong. They can either have 1 hour together or they can elect to have 2 hours, one for each separately. So either way, each parent gets an hour. It's just, if it's together, it's one. If it's not, then you each get your own hour. I'm going to defer child support and medical support at this time. Court makes a finding the parties have stipulated that the Department of Family Protective Services made reasonable efforts in this case, and that the stipulation under 262.013 that the agreement of the parents is not an admission of the allegations is also noted as part of the agreement. Court's going to order that care and before and after school care be provided by Belong, daycare during the summer, and the before and after school care, obviously when school starts. We're going to come back for a status hearing on August 21st, 2024 at 11 a.m. August 21st, 2024 at 11 a.m.
Your Honor, that was daycare during the summer?
Well, my understanding was that there was a request for
Yes, sir.
assistance during the summer and then before and after school care. So
Thank you.
I'm just going to order that whatever needs to be done to assist the placement during the summertime, whatever that looks like, we talk about it at the family group conference and figure out how to address it.
Yes,
I have to admonish the parents that the state of Texas gives parents in CPS cases 12 months to demonstrate that you can provide a safe, stable, violence, and drug-free home for your child. If you cannot demonstrate that within the 12-month period, your rights to your child are subject to further restriction, like they are now, or termination. Again, we're going to have that status hearing towards the end of August. So what needs to happen in between now and then is that you both need to make a lot of progress. We're going to have a family group conference. Everybody's going to sit down together and figure out what it is that needs to happen in this case for you all to address these concerns and to get on a path towards reunification with your daughter. It's going to go by fast. A lot's going to happen, and you've got to keep up with it. And you can't just say you did stuff. You have to engage in these services and learn something and improve whatever it is that's lacking or whatever it is that's not working, so that we get to a point where I can start giving you more and more time with your child and eventually reunify with your child. That's what we want to see happen in this case.
Okay.
But it all depends on how much work you do and how hard you do it and how much you stick with it. I'm hoping that we come back on August 21st and I hear really good reports about your engagement and your participation in your services. All right. Is there anything I failed to address?
No, Your Honor.
no,
Okay.
Your Honor.
Mr. Spence, Ms. Gonzalez, good luck to you both. And for everybody else, thank you for your time and your service. If there's nothing further, all parties are excused. County,
Thank
Texas.
you.
Court is broadcasting from Kendall County via Zoom and YouTube. Any objections?
No.
No objection.
No, Your Honor.
Mr. McKeska, would you please begin the announcements?
Yes, Judge Drake McKeska, attorney for the department. Ms. Cecil?
Regina Cecil, investigator for the department, caseworker.
Deborah Perry, attorney for mother. Haley Lopez.
Ms. Lopez, can you announce, please?
Haley Lopez, mother of the children.
Jennifer Harris, attorney ad litem for the children.
Jessica Cervantes, bilingual family advocate and forensic interviewer for Kids Paradise. I'm sorry, I got nervous here. Kids Advocacy Place, Hill Country Crisis Council.
Thank you. Okay, it's been brought to my attention. Ms. Mance was appointed to represent Ms. Lopez. She has since retained Ms. Perry. Have the parties talk about how you want to proceed today?
Yes, Judge. Ms. Perry and I did speak a little over an hour ago. It was my understanding that she was going to be asking for continuance today. There are a couple of forensic interviews that she would like to be able to view prior to moving forward with the hearing.
Is there any objection from the department?
No, Judge, there's no objection.
Ms. Harris?
No objection, Your Honor.
All right.
Objection.
Okay, then, what I would need to do is have you all decide on how long you need Ms. Perry to interview or review the interviews, excuse me, and then reset it for a special setting, but inclined to order the parties to mediate it as well within that time.
Okay.
Is there going to be any issue with that I'm not aware of?
No, in fact, I think that's a great idea, Judge.
Ms. Greenlee, when can we get another setting on this? And if for some reason you all can't come to an agreement, how much time would you need? I mean,
An hour, Judge.
Court-ordered services, yeah, I'm usually looking at an hour, 2 hours max.
I think 2 hours is plenty, Judge.
All right, Ms. Greenlee, what do we have next for 2-hour setting? That'll give them time to do the interviews and me. I'm thinking a couple of weeks.
That should be more than enough, Judge.
All right.
That is fine, other than I just would like the court to know I'm going out of the country from the 8th through the 17th of August.
Okay, we'll be before then.
Before that, okay. Thank you, Judge.
So they're wanting 2 hours?
I want to make sure that we have, I'm hoping it's only about an hour, but I want to make sure we have 2 hours available in the event it runs late.
Well, I mean, we have the 1:30, we have 1:30 on the 18th. We could give it the 2 hours then. I know we have.
The 18th works for me as long as the department will have the forensic interviews. I can run over there and look at them before that.
Yeah, we shouldn't have a problem scheduling that, Judge.
I mean, or we could set it at 10:30 because we have a 9:30 that's set for an adversary. We could do it at 10:30 because I know on the 9th we're going to have a reset as well. And that's the only date I have for that reset as well.
The question is, can we also mediate it before then?
Well, if you can't, we don't have anything until August because Judge is out of town and we don't have another date.
That's 17 days. I think that's almost 3 weeks. So I'm going to reset it to July 18th, 2024 at 10:30.
Alrighty. Thank you, Judge.
You're welcome. That's July 18th, 2024 at 10:30. And then I'm going to order in that reset that you all sign it. There's no objection to extending the court's order, correct?
No, Judge, it's an empty piece. There's no emergency temporary orders.
Okay. All right. Okay, then anything else we need to take up today? Let me go ahead and ask Ms. Cervantes, since she's here. Ms. Cervantes, are going to be any issues getting those interviews either to the department or make them available to Ms. Perry?
We already have them, Judge.
Okay, then that takes care of that as well. All right, then that's the order of the court. Nothing further. Thank you all for your time and your service. All parties are excused.
Thank you, Judge.
You're welcome.
Thank you, Your Honor.
You're welcome. Thank you. Mr. McKeska, I see that you have Ms. Cecil here. Do you need anyone else?
No, Judge. Ms. Cecil's here. Ms. Evans is the covering supervisor. And Ms. Harris is here. So I believe we're all here.
Department of Family Protective Services versus Haley Lopez in the 198th Judicial District Court of Kerr County, Texas. The court is streaming from the Kendall County Courthouse via Zoom and YouTube. Are there any objections?
No, Judge.
No objection.
With that, Mr. McKeska, would you please begin the announcements?
Yes, Judge. Drake McKeska, attorney for the department. Ms. Cecil.
Regina Cecil, main investigator on the case with the department.
Deborah Perry, attorney for Miss Lopez.
Haley Lopez, mother of the children.
Jennifer Harris, attorney ad litem for the children. I'm ready.
We go. Jessica Cervantes, bilingual forensic interviewer and family advocate for Kids Advocacy Place, Hill Country Crisis Council.
All right, Mr. McKeska, how do you wish to proceed?
Judge, if I know Miss Perry and I have been having some phone calls over the last day or so, and we just spoke a few minutes ago. So I think maybe if we could get a breakout room just so we could tie some things up and see which direction we need to go, and it should be pretty quick.
That'll be fine.
Thank you, Judge.
You're welcome. All right, I've got the 3 attorneys in breakout room 1.
Thank you, Judge.
You're welcome.
We're back, Judge.
Okay. Are we ready to proceed?
Yes, Judge.
All right. Go ahead, Mr. McKeska.
Judge, after conferring, we were able to reach an agreement for how we're going to proceed today.
Okay. What is that agreement?
So, Judge, the department has agreed to dismiss the petition under 264-203 and seek a court order under the provisions of TFF, the TFF case, or under the TFF provisions of the Family Code. And as part of the order for TFF, only have Ms. Lopez and the kids participate in brief strategic family therapy, and that be the only service on the family plan of service.
So you're going to dismiss the COS, refile as a TFF, and only do brief strategic family therapy?
Yes, sir.
Ms. Perry, is that your understanding of the agreement?
Yes, it is.
Ms. Harris?
Yes, Judge, and I think it's in the best interest of the children.
Okay. Ms. Cecil, do you believe that this is in the best interest of the children?
Yes, Your Honor, I do believe so.
Okay. All right, Ms. Lopez, do you understand that when that suit is refiled based on this agreement, you're agreeing to do those services, consent to that suit? You understand that, correct?
Yes, Your Honor.
You've had the opportunity to discuss that with Ms. Perry?
Yes.
Okay. Anything further then, Mr. McKeska?
No, Judge.
All right. Based on the agreement of the parties, the court finds that the agreement is in the best interest of the children. The court will adopt and approve the agreement, and under the understanding that this court-ordered services case or required participation shall be dismissed, and a Texas Family First case will be filed with the mother and the children participating in brief strategic family therapy. Okay, there'll be no further hearings on this case, and I'll sign the dismissal order when I get it.
Thank you, Judge.
Thank you, Judge.
All parties are
Thank you,
excused.
Judge.
You're welcome. Thank you.
And Judge, that wraps up the morning docket.